All right, so are you Trishad Tarrant? And
We're starting with a major one, a plea deal in a murder case. Pay close attention to how the judge responds to every single word, because in plea hearings, accuracy and careful wording make all the difference.
this is 24 DCCR 1217. And Mr. Brewer, will your client waive the formal reading of the indictment?
We will.
Mr.
Mr. Cook.
Mr. Cook, I'm so sorry. There's
Mr. Brewer was the guy that's actually. He's on
Gotcha.
vacation.
Thank you, Mr. Cook. And Mr. Tarrant, before we get started, I'm going to make sure that we're all on the same page. I know the clerk had you swear in, but she said that you didn't answer out loud, so I want to make sure we are all clear, that the record's clear. So the best you can, would you please raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. And it looks like in cause number 24-1217, the state has elected to proceed on the lesser included offense of the first-degree felony murder, and that.
Notice how fast he says guilty. There's no pause at all. In court, that kind of speed can be seen two different ways. It might show genuine acceptance of responsibility, or it could mean he just wants to end the process as quickly as possible. What do you think?
From May 21st of 2021, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Cook?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right, or not the district attorney, the state's attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement, is that an 8 or a 0? Is it 20?
20 years ago.
Okay. The pins are, make it a little bit
Yeah,
funny.
could you please get the 2 and put an 8?
I got, yes, sir.
Makes it
Yes,
a
sir.
little bit different.
Yes, sir. And so, do you understand, if I follow this agreement, you're waiving any right to appeal?
Yes, ma'am.
Also, sir, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tarrant is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of murder.
Here's the key detail. The judge orders the sentences to run consecutively, not concurrently. That means they don't overlap, but instead stack on top of each other like building blocks. In simple terms, he must finish serving the first sentence before starting this additional 20 years. It's a huge legal difference and exactly the kind of outcome most defendants hope never to face.
Sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run consecutive to cause number 16808 out of Van Zant County, Texas. I am going to hand you in just a second the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You are also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Cook. And it's my understanding that there
Even when it's given through a screen, a victim impact statement has the power to completely change the tone of the courtroom for the family. This moment is their single chance to ensure that both the judge and the defendant truly hear and understand their pain.
the victim impact statement, is that correct?
Yes, Your Honor.
Okay, let's do this. If we can, Mr. Lewis, I'm sorry.
Yeah, I was gonna submit it to the court, Your Honor.
Oh, okay. I didn't know if somebody was here or if they
They're
wanted
watching on Zoom.
Okay.
They're watching the proceeding. I'm in communication with them. They're fine with me submitting it.
Okay. Thank you. And did you want to read it out loud for them or just submit it to the court?
I can read it out loud.
Okay.
It's not very loud.
Okay. Yes, ma'am. And we'll go off the record.
That single line, "We prepared his room," cuts deeper than any legal argument ever could. This is exactly why courts allow victim impact statements. They bring a human side to the case, reminding everyone that this isn't just about paperwork and laws, it's about a real life that was lost.
I wanted to know why this happened. I was extremely sad and just miss him. I felt helpless because I knew I was never going to see him again. I wanted answers. I wanted to hug him. I thought he was only going to be at that facility 3 days and then he was going to be released. We even prepared his room for his arrival, but that day never came because he was murdered. My son was not a rebellious person. He had reconciled with the Lord and was ready to come home.
Thank you, ma'am. Thank y'all. You're free to go back with the bailiff.
Does he get these copies?
Yes, he can have those copies. All right. Thank y'all. Good morning. Are you Edmone Latulis? And this is 24-2057. Ms. Latulis is charged with abandoning or endangering a child. And what is the announcement?
We've met a couple of times, me and Mr. Hoffpower. This involves the death of a child, and so we're still needing a little bit more time.
Sure.
There's also another, we've got a cop, co-defendant, a driver of the vehicle.
Okay.
She was the passenger.
So we're not sitting on this by any stretch.
Yeah.
We've been talking, it's just a unique one, and there's a lot of
So I'll do a normal reset so y'all can go through more discovery, see where you get. Ms. Latulis, make sure you stay in touch with Ms. Holmes so that you know what's going on. And when she receives information from Mr. Hoffpower, y'all can go over that together and we'll see where we get at the next court date. All right? You're free to go. Good morning. You're Zuli Valasila. And Ms. Valasila is charged in 24 DCCR 1364 with burglary of a habitation. And what is the announcement?
Yes, Your Honor. I spoke with Mr. Nichols previously. There is some information that he would like for my client to provide to the state that we're working on.
Okay.
So we can get some time to get that.
All right. Any issues that you see?
Judges, with respect to some additions.
So I'm going to do just a normal reset. Any information that you have, you need to make sure and get that to Ms. Holmes quickly so that she can get it to Mr. Nichols, and that way we can see where we are at that next court date with regard to an announcement, okay? All right, you're free to go. Thank you. Good morning. You're Crystal Vogan. And will your client waive the formal reading of the indictment?
She does, Judge.
Ms. Vogan, in clause number 250026, you're charged with the state jail felony offense of theft of property from February 9th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Now notice the sharp contrast: 20 years in prison for murder compared to probation for theft. That's the balancing act of the justice system. The punishment has to match not only the crime but also the circumstances surrounding it. Quite a wide range, isn't it?
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I've got to ask everyone. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Vogan is not competent?
No, Judge.
Is there restitution or no?
Your Honor, I believe that was covered, but I still think they would need to do a PSI.
Okay. All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right? We'll see you back at sentencing. Thank you. Good morning, sir. You're James Rucker.
Yes, ma'am.
And this is cause numbers 241348 and 241349. And what is the announcement?
Judge, first, this was the one where the government had to do an amended indictment. That was done. So my pending motion to quash, I believe the court can just simply ignore. We're now satisfied with the
That's what I
indictment.
wanted to find out. So you are satisfied with the way it is, then I will grant that second motion to amend the indictment, make that modification, and then the motion to quash will go away. All right, so where does that leave us then?
I think the state's in a position where we'll be making an offer pretty quickly and hopefully we'll get this thing.
Okay, so I'll do one more reset. I'd like for this to be close to the last one. If y'all can get any offer, y'all talk about it. Make sure you stay in touch with Mr. Gallimore, and then we'll see where we get at that next court date. All right, you're free to go. Thank you.
I'll send you